So the lawsuit filed by a Jane Doe against Irv Gotti is only 4 pages long. Let's take a look at it and you guys let me know your thoughts. Shout out to Drea also for pointing out that it was available. So, in the Circuit Court of the 11th Judicial Circuit in and for Miami-Dade County, Florida. And you can see here Jane Doe versus Irving Domingo Lorenzo Jr., aka Irv Gotti. Plaintiff Jane Doe, by and through her undersigned counsel, hereby states her complaint against Irv Gotti for SA and, the R word, based upon personal knowledge and information and belief. So they're going to establish the parties here as the Jane Doe, who was living in Florida during the relevant time period, and then Irv Gotti, who is an American DJ, a music producer, a record executive, and the CEO and co-founder of Murder Inc. Records. Now, jurisdiction, why we need to file in this court is the amount of controversy, the amount of money in controversy is going to exceed the jurisdictional limits of all the lower courts that may otherwise have jurisdiction. So, even not counting interest and costs like attorney's fees, the amount that the Jane Doe is seeking in financial compensation exceeds a certain threshold. And here we can see that with the 11th Judicial Circuit, these are those thresholds. So the Circuit Civil Division hears cases with damages in excess of $50,000. So this venue part says it's proper in the Circuit Court of the 17th Judicial Circuit. I don't know if that's a typo. I think we're probably in the 11th Judicial Circuit because that is Miami-Dade County. And then the 17th Circuit is Broward, slightly north. It's like right next to Circuit 17, or Circuit, it's like right next to Circuit 11, but it's different. But in any case, it looks like the jurisdictional amounts would be the same, seeking above $50,000. And then here's the statement of facts. So this is what's being alleged by the Jane Doe. Plaintiff met Irv Gotti through a mutual friend at a poker tournament in the summer of 2020. So probably not Ashley Martell. Gotti invited plaintiff to go on vacation with him in St. Martin, or San Martin, however you want to say it, to which she agreed. After flying her to St. Martin, Gotti coerced plaintiff into having sex with him. Gotti specifically threatened plaintiff that he would send her home if she did not comply with his demands. Accordingly, and due to his power and influence in the music world, she complied. Following the trip to St. Martin, Gotti and plaintiff entered into a relationship where, for 2 years, plaintiff suffered constant abuse at Gotti's hands. During this abusive relationship, Gotti demanded that plaintiff perform unwanted sexual acts and often berated and scolded her. Notably, in January 2022, Gotti flew plaintiff out to Miami, and the two stayed at the Four Seasons Hotel. There, Gotti forced her to perform oral on him in an elevator. Later in the summer of the same year, he flew her out to Atlanta, and he again forced her to perform oral on him in an Uber. Following this event, the relationship ended. As a result of this sexually abusive relationship, plaintiff has suffered severe emotional and psychological harm, for which she has had to be committed to a psychiatric ward. These injuries continue and affect plaintiff to this day. Moreover, plaintiff has been made aware that Gotti is slandering her to his vast social network in and around Los Angeles. As a result, and in addition to the severe emotional distress described above, plaintiff now fears leaving her home. So her causes of action are SA and battery. Claim 2 is intentional infliction of emotional distress. And plaintiff Jane Doe is seeking a jury trial for all triable issues. The relief that she's requesting: compensatory damages, including those for mental anguish, in an amount to be proven at trial that exceeds the jurisdictional limits of all lower courts, that $50,000, that may otherwise have jurisdiction, an imposition of penalties available under applicable laws, litigation costs and expenses, including attorney's fees, and any other relief that the court deems just and proper, submitted by her attorney Adriana Alcalde, who works for Eisenberg and Baum out of New York. So with a cursory look, I don't really know if this is the social media that she'd be referring to. Maybe it's a different platform. Maybe he's taken stuff down. But I'm not entirely sure where the slandering is taking place. So maybe it was in the stories, which I can't see anymore since it's been more than 24 hours since they were posted. But I do think that that's a really interesting mention here in line 14, that plaintiff has been made aware that Gotti is slandering her to his vast social network in and around Los Angeles. So she's been made aware of it, but I can't find it, so I'd have to wait until that's actually produced to weigh it one way or another. But what's interesting is that slandering And then this next line, as a result, and in addition to the severe emotional distress described above, plaintiff now fears leaving her home. But the causes of action, we don't really see one for slander. We see that this intentional infliction of emotional distress stems from the aforementioned essay and battery. We don't really see a specific cause of action relating to the slander. It's kind of just in here as an ending note. So what are your thoughts on that part? And then additionally, I think it's interesting, in line 13, we have this plaintiff has suffered severe emotional and psychological harm for which she has had to be committed to a psychiatric ward. These injuries continue and affect plaintiff to this day. Now, it's possible we could come to see that this psychological harm is the trigger of what made her have to commit. But is it something that Irv Gotti would necessarily be liable for? It'd be interesting to see if a jury finds the chain of liability. So this is really underdeveloped here. Again, this is just a 4-page filing. So I would expect that we hear a lot more about this if this moves forward. But until then, we'll have to see. And ultimately, I think one of the big things that pops out is we met sometime around 2020. We go on this trip. The abuse happened then already. But then we get into a relationship after that. And this all happened in another place. So I wasn't necessarily stuck with you after this. I could have been physically separate from you after this. But then we enter into a relationship. And if this goes to trial, she's going to have to explain to the jury why that was. Now, her attorney here specializes in helping victims of DV, SA, police misconduct, trafficking, and CP. She used to be a prosecutor in the Broward County's state attorney's office and helped prosecute a lot of special victims' crimes. And during her time with the homicide unit, she never lost a murder trial. And it's just weird that the record label's Murder Inc. So she was also charged with prosecuting police officers and public officials accused of official misconduct and corruption. She's taught law school seminars instructing young lawyers in trial and litigation skills. She's a regular speaker on issues relating to civil remedies for victims of sex crimes or police misconduct. Miss Alcalde has also been a commentator on national and local networks, commenting and discussing legal issues and her own cases. And we're going to look at a statement that she made about this case. But here are some stories that she's highlighted for. Presumably while she was a prosecutor, jury convicts ex-Miramar police captain of ordering girl 15 years old to expose herself. Former youth pastor gets nearly 29 years in molestation case. There's a guilty verdict in a Coral Springs murder trial. Ex-Seminole police officer found guilty of molesting female relative. DNA evidence exonerates Canadian tourist murder suspect. So Alcalde said we're not going to move forward now that we see this DNA evidence. So, due to the issues with the DNA and the only eyewitness to the case now having serious credibility issues, the state cannot go forward in good faith with the prosecution because there was no reasonable likelihood of conviction, wrote prosecutor Adriana Alcalde Padron. Also a capital case where man was given life sentence for killing adoptive mother. Jury finds deputy guilty of lying in videotape takedown at Tamarack 7-Eleven. Suspended cop under house arrest is caught in strip club after taking off his ankle monitor and sneaking out. Hold on, what's that story? That sounds dramatic. Daily Mail published it, of course. So Waddell is the suspended officer. And so it looks like here, Alcalde, as an assistant district attorney at this point in time, made the argument that, look, take him off house arrest because he's out here, he's contacting witnesses, he shouldn't be doing that. These are violations of his terms of bond. And this cop was allegedly out here, and maybe there's a conviction at this point in time, we're not going to dive deep into this. But he was out here, he was apparently caught in the act of stealing $1,340 from a drug dealer he had just arrested. And then he's put on house arrest, takes his ankle bracelet off, his ankle monitor off, and goes out to the strip club past his hours. And then we have prosecution for someone that stole $165,000 from the Broward Teachers Union. Walt Disney ex-cop gets 90 days behind bars. And Hialeah ballot broker's note lists candidates' names and payments. So maybe there was some corruption going on there. But yeah, so this is her attorney's background, and she has given a statement to People magazine. They do note that they tried to reach out to Representative Gotti, but they didn't reach anybody at the time. And they've got this statement here, and they spelled her name wrong. But it says she suffered a lot. The plaintiff's lawyer, Adriana Alcalde, tells People before citing the Me Too movement for helping women feel more comfortable in speaking up. Now I think women feel a little more empowered to tell their story. So there you go, you guys. I will link to the 4-page document in the description. It'll be a Google Drive link. Let me know your thoughts on this. This is obviously a really short and concise. It's 4 pages long, including all the information that needs to be attached in the signature. So really, really short. I do think it's interesting that we don't have a cause of action relating to slander, but it's mentioned in the statement of facts. And it's not even recalled in the cause of action relating to distress, infliction of distress and emotional harm. But it's in there as a detail. We'll see if more is hashed out about that. And I don't necessarily discount, even though I personally question it and know that in front of a jury, you'll have to address and explain why somebody would get into a relationship after some form of abuse had already occurred, as alleged. That's kind of what the New York Weinstein case involved. Not the Molyneux witnesses, but the witnesses that were actually part of the charged crimes against Harvey Weinstein. They had been in relationships with him too, and that didn't seem to bother the jury as far as we can guess and speculate, since they convicted him. I think the background here is interesting, and I think the transition into private practice on the civil side is also pretty interesting. And I want to thank you guys for bringing this to my attention. It's been a busy day, but, making time for 4 pages was pretty easy. And I think this might be a good one to watch. I mean, we have a former prosecutor with a successful track record. No losses when prosecuting murders. Taking up a civil case against the owner, the CEO of Murder Inc. Records. So that's just interesting. I'm poking fun at it. But you guys all take care. Make sure you let me know your thoughts. See you next time. Bye-bye.